Welcome to the London Property Podcast, your go-to source for navigating the complex and ever-changing London real estate market. Our digital marketplace provides informative and educational content from industry leaders through podcasts and videos. We cover various aspects of the real estate experience, including buying and selling, finance, law, tax, construction, design, and more. Join us as we delve into the latest trends and developments in the market and gain valuable insights from our panel of experts.
Hello and welcome to London Property. I am your host Farnaz Fazaipour and we're delighted to welcome back to the show Matt Bird, who is an expert in tax planning. I'm going to pass it over to Matt to make a little introduction about him and his experience to date, and then we're going to discuss the subject of inheritance tax.
Okay, thank you very much.
Pleasure.
My name is Matt Bird. I'm a tax partner at Sayers Butterworth. We're a firm of chartered accountants, tax and business advisors in central London. I'm a chartered tax advisor and frighteningly now have more than 25 years experience in predominantly private client tax, but a large part of my career has been advising UK residents who can also be non-domiciled individuals with their sort of offshore tax issues and sort of their affairs on arriving in the UK and their sort of tax liabilities and obligations.
So let's start with talking about inheritance tax and what are the basic rules? So, what are the exemptions and let's just talk about first the baseline.
Okay, so in very simple terms, inheritance tax is paid on a person's estate on death. That is for the vast majority of people the time when inheritance tax is payable. It is payable on all their UK assets and also depending on the length that they've been UK resident for on their worldwide assets. The rate is 40% on assets more than 325,000. There is an additional 175,000 which applies to the family home, but that is withdrawn if you go over a certain level of assets personally. It also includes in your estate gifts which you have made in the 7 years before your death. So people may be familiar with the idea of the 7-year rule about making gifts sooner rather than later to ensure that they're not part of their estate. And it can also include gifts that an individual has made where they've retained a benefit or an interest in some way. Typically, I as an advisor and other advisors will be asked about, can I give away the family home to my children but still live in it? And the simple answer is, unless you will be paying market rent, you can, but it will be you'll still be paying inheritance tax on it because it will be included in your estate. So it does apply to all UK assets, and from sort of changes a few years ago, it also applies to residential property, however held. So indirect holdings in, say, a non-UK company that derives most of its value from UK residential property, the value of those shares would be part of your estate. So this change has caught, going back probably since the 1980s, possibly before, the advice has always been was to buy residential property in a non-UK company, because you looked at the company shares which were non-UK rather than the property it owned, which would be UK. So that was a way of avoiding UK tax. But there have been a number of changes and now that planning, it doesn't work because those shares are now caught.
Right, and there was something about it being 75% residential real estate, but has that been abolished as well?
Well, there are some rules for whether the shares are subject to capital gains tax, and there are also rules about inheritance tax. Yes, I think fundamentally is that if you have a residential property that is owned by a company, and you haven't yet taken advice, now is the time to take advice. Not least because sort of more than 10 years ago now, a tax was introduced called the annual tax on enveloped dwellings, and that applies if effectively people connected with the shareholder of a company use the property, even if they pay market rent. So there are issues with, again, it comes back to a structure that may have been compliant and efficient 15 years ago, 25 years ago, whenever it may be. There have been big changes over the last 15 years or so, and those structures should really, if they haven't already, they should be reviewed, because there could be some quite large tax liabilities building up now.
And this 350 exemption was set when? Because obviously property prices have gone up since that time, but this has never been addressed, which also is not very fair.
Probably, I can't remember for certain, sometime around 2005, 2000. It may have been somewhere around 2007, and it was frozen for a while. It was then going up, and it hasn't moved for nearly 20 years.
Yeah, so that's something to be addressed for sure. And, it is a bit of an unfair tax, because a lot of people have already paid tax on the money that they've used to buy those assets, and then now they're being taxed again. I guess we're trying to avoid having a lazy generation by giving them lots of money, and then they don't have to work afterwards. I don't know. The logic is there, I'm sure.
Yes, I mean, I suppose, and I'm fully aware no one really likes paying inheritance tax. You can console yourself with the fact that for most people, inheritance tax
is not painful. They're not here.
Well, yes, it's payable by your executors, not by you.
Yeah.
I mean, it is also, inheritance tax also applies to trusts. So that is also a big concern for people, because UK assets held by a trust, or any worldwide assets held by a trust, if it was set up by a UK domiciled individual, those assets are subject to a inheritance tax charge every 10 years. And that is a maximum rate of 6%. And so that will apply without necessarily the trust having the money to pay it. So that is an issue, but that is something that people have to balance, whether a trust is right for them.
Well, I was just going to say, while we're on the subject of trust, what's that 6% tax that you can pay every 10 years?
10 years. So that it's on the 10-year anniversary of the trust. As it stands now, it applies to all of the trust's assets if it was created by a UK domiciled individual. It applies to UK assets if it was created by a non-UK domiciled individual. And there are a few exemptions for trusts which were created either on an individual's death, which leaves a right to income for the surviving spouse, or there is a right to income and the trust was created sort of before 2006, 2008. But yes, it's basically the intention, as I understand it, was that the 6% charge would more or less equate to a 40% inheritance tax charge on someone's death. So by the time you had 7 lots of 10-year charges, which would span 80 years, you would pay 42% tax in total, and someone dying around their 80th birthday would pay 40% inheritance tax. So that is sort of the rationale, as I understand it originally.
Right, but then if you're paying the 6% every 10 years, and then that carries on with your children, the children of your children, then I suppose it is a way of mitigating inheritance tax with the current rules.
Yes, I mean there are lots of reasons to have a trust. It can be, fundamentally a trust is there for asset protection. It is to sort of protect children from themselves. It is to protect assets in the event of bankruptcy or divorce. It is to ensure that assets are available going down the generations, whether that's a house or whatever it may be. So a trust can have, there is very good rationale for having a trust. A trust can also have advantages if you are buying UK residential property for use by, say, children to use whilst they are at university in London or Britain, if somewhere, in the UK. And that is really then a balancing act between the inheritance tax exposure potentially on the trust and weighing that up against the fact that assuming that the trust deed is drafted correctly and so forth, that the property will qualify for the principal private residence, the main residence exemption, if it is used as a main residence by a beneficiary. Right. So you are avoiding the capital gains tax exposure potentially if the trust property is used by a beneficiary as their main home.
And you don't have to pay ATED under that structure?
Not at a trust level.
That's something.
But that is down to personal choice.
But you're paying the 6%, so you need to be liquid enough to pay the 6% every 10 years in order to have this kind of setup.
No, absolutely. So it fundamentally, it's a way of managing a capital gains tax exposure, balancing that with a potential inheritance tax exposure. It is, because you could avoid both if you're just owning the property for a short period of, say, 8 years to allow 3 children to slightly overlap to study, and then you sell the property. But everyone's situations are different.
Yeah.
So, but it comes back to, taking advice for your own circumstances.
Personal circumstances. So now going to the subject of the changes in inheritance tax that have been quite controversial and have kind of, no pun intended, put the nail in the coffin when it comes to non-UK nationals actually exiting. So can you talk to us about what the new regime says about IHT? So
up until now, inheritance tax has been based on an individual's domicile, their domicile of origin. And this is quite domicile is distinct from residence, and is very much a sort of a UK concept. That there's not a similar concept in sort of continental Europe, for example. You are really looking at where someone considers their true home to be. So it's not necessarily where you live. It's typically you take on your domicile of origin is taken from your father's domicile when you are born. And there has always been some confusion or ambiguity. On one hand, it's very clear to tell when someone is non-domiciled in the UK, and it's very easy to tell when someone is domiciled in the UK, or technically England and Wales, Northern Ireland, or Scotland. But in the middle, there was always an issue regarding whether someone who'd been living in the UK for many years had acquired a domicile of choice. And in some circumstances, it was difficult to properly determine that when potentially there were significant amounts of money at stake. And likewise, if someone had moved to live outside the UK, you had to determine whether that move was permanent, whether they had sufficiently cut their ties with the UK. And so there were some questions about, could you guarantee to a client that they weren't subject to 40% inheritance tax, or could they create a trust and not have to pay a 20% inheritance tax sort of entry charge? And there are a limited number of double tax agreements covering inheritance tax, and these are distinct to the much greater number of double tax agreements which cover income tax, capital gains tax, in corporation tax. And they're sort of India, Pakistan, Italy, France, America. But so for the vast majority of people, there isn't any relief from a double tax agreement. So from the 6th of April, we are moving to a residence-based test, which provides certainty because you can use the statutory residence test to determine if someone has been resident for in 10 of the previous 20 tax years, and you can say yes or no. The one caveat to that is I think that anecdotally, HMRC have started taking a greater interest into claims to be non-UK resident, and asking questions about, there are a number of ties that are defined which reduce, the more ties you have, the fewer days you can spend in the UK before you become UK resident. And there seems to be a greater focus by HMRC, and again, this is anecdotally, but it would be in their interest to do this, asking people, how many days did you work in the UK when you were here? Because working in the UK for sort of 30 days creates a tie, so reduces the number of days you can spend here. Do you have available accommodation? So, and that can include staying with a sort of at your parents' house if you have a room and a key, and you sort of spend a relatively short period there in a year. So, but putting that aside, basing it on residency is a good step. There are questions about whether it should apply after only 10 years. And because the test is, were you resident in 10 of the previous 20, it can apply after even if you've left in year 11, or after 9 years and 2 months, you will have been that 2 months means that you were resident in year 10. So you are then caught. So in effect, it means that people will have to leave in year 9.
And that's why you need tax advice. Right. Okay, so basically, one of the things that I heard is that if you were resident for 10 years, then you'd have to be outside for a full other 10 years in order not to have to pay inheritance tax under the UK regime.
Yes, there's a sliding scale that was introduced in Rachel Reeves' budget, that once you've been resident for 20 years, it's 10 years of non-residence.
Okay. But
there's a sliding scale which reduces that if you've been resident for 10 years or 11 years and 12 years. Again, it's not fully in for having to do 10 years, yeah. But for some people who have been living in the UK for 30 years, 40 years, it will require a full 10 years of non-UK residence.
Yeah.
But these new rules don't just apply to people who are non-UK domiciled under the old rules. So it does apply to someone who was born in the UK, who has a UK domicile of origin. They will now be able to avoid UK inheritance tax on their non-UK assets once they've been non-UK resident for 10 years. So,
so retirement away for the last 10 years of your life?
Effectively, yes. I mean, if you can look that far into the future.
Yeah. Well, I mean, gifting it to your children early is really trust your children.
Retire at 65.
Yeah.
Move abroad. Do 10 years. Return to the UK at 77. Your worldwide assets are then outside of UK inheritance tax. And you can make gifts of those non-UK assets. And, you know, putting it cynically, die at 85.
Right.
And you're only paying inheritance tax on your UK assets. So that is potentially, I've seen some people mention that, but maybe there'll be some sort of kickback when people realise that some sort of British-born billionaires have avoided inheritance tax by living in Monaco for 10 years.
Yes, selling their plumbing business was in the news. So anyway, so actually it's not as dreadful. Because if you're planning it and if you can try and figure out, you know, something that suits your family and your lifestyle, it's not as dreadful as people, the way that people are reacting.
I think if you can, it depends where you are. So obviously if you're in later life and these changes have taken effect, you haven't potentially got in a position to do 10 years of non-UK residence. You might not want to, you may want to, if your family and grandchildren are in the UK, you may not want to move. So again, everyone will have their own view on this. Trusts which were set up before the budget at the end of October, they continue to be considered excluded property, which means that they continue to be outside of assuming the person who created it is also a beneficiary, those trusts are not in that individual's estate, whereas new trusts, the inheritance tax treatment will follow the residency of the settlor. So if the settlor is UK, he's been resident for 10 years in the UK, not only are the individual's worldwide assets subject to inheritance tax, so too will be assets in any trust that was created since October. So it is made the decision whether to set up a trust is a far more complicated, nuanced decision to make. But then my view on inheritance tax to a degree is that it's one, the individual doesn't pay it, so they are trying to protect their family, which I'm not saying is wrong, but you are also taking potentially very decisive steps to avoid a tax that may not be payable for 20, 30 years. And anyone who has been sort of advising on UK tax and inheritance tax for more than 20, 30 years will be able to tell you that the rules, particularly all tax rules change, but inheritance tax is changed with, there were inheritance tax planning involving reversionary leases. The rules were changed to affect that. There were inheritance tax planning rules with it was called the home loan trust or double trust structure, whereby you would sell your main residence to a trust in exchange for an IOU and then sort of make a gift of that IOU to reduce the value of your estate. Firstly, that And there was a flurry of these put in place to be put in place before stamp duty land tax was introduced, because under stamp duty you could rest on contract. So you could sell the property but avoid having to pay stamp duty. But shortly after I think it was, from memory, within days of stamp duty land tax being introduced, the pre-owned asset tax was introduced, which meant that if you could use an asset that you previously owned but had sold, you were charged on a tax charge based on the benefit you were receiving. So, and then HMRC mounted a series of challenges, arguing that the double trust structure didn't work for inheritance tax anyway, or wasn't as efficient as it claimed. So there have always been changes to inheritance tax. So making steps that can be expensive and also expensive or impossible to unwind if rules change, to avoid a tax that may not be payable in sort of for another 20 years. I think people have to be very careful in going with their eyes open. Because for some people, rather than going into complicated structures, you can take out life assurance.
Exactly. I actually interviewed someone on that subject. Yeah.
And the starting point as well is also, the two main things is, one, to make sure your will is written tax efficiently, because gifts between spouses are exempt from inheritance tax in most cases, and put in place life assurance, so you know that even though inheritance tax is payable, the insurance is going to pay it.
And stop smoking and do your exercises and eat well, so that premium is minimised. Yeah.
Yes. So there is. So I think that is the important thing to note, that no one likes paying inheritance tax, and I fully understand the aversion if you feel that you are in the UK but you have assets around the world that in your eyes have no connection to the UK, that suddenly they will be subject to 40% inheritance tax. I get that completely. But for people who start trying to plan with sort of UK assets, sometimes just keeping things simple is the best option.
Excellent. And you mentioned some countries that there's treaties with, so I'm assuming in those countries it's the inheritance tax of the other country that applies to those people.
Yes, and the treaties which are typically most sort of have the biggest headlines are countries which don't actually have inheritance tax. So there is a double tax agreement between the UK and India, and as things stand, India doesn't have inheritance tax. So they win. When it comes to a person who's exposed to both countries. If the taxing rights are awarded to India, then India has the taxing rights on non-UK assets. So inheritance tax will always apply to the UK assets. And one last question, and then I will say thank you. Does religion come into it? Because obviously you've got Sharia law when it comes to, or not really, it goes the same way. That just applies. Inheritance tax just applies to who assets are, on death. There are some exemptions if they're left to a spouse. There are exemptions if they're left to charity. But as far as I'm aware, it's payable regardless. Brilliant. Well, I think if that doesn't convince you that you need tax advice, then you've definitely been listening to the wrong podcast. Thank you very much. Thank you. This was really, really informative. And if you have got questions, and if you are being frightened by the current changes in IHT and wondering what to do, then do please get in touch with us, and we'll make sure to put you in touch with our specialists who can guide you through, navigate this complex issue. Thank you. Thank you.
Thanks for tuning in to our latest episode of the London Property Podcast. Head over to our website where you can browse our exclusive network of top experts driving the market. As a member, you'll have direct access to our experts and their networks. Our award-winning content will help you choose the right professionals for your needs and make informed decisions about your investments. Personal recommendations are a powerful tool in connecting with trusted professionals. Let us introduce you to the right people to help you achieve your real estate goals. Contact us now to learn more about becoming a member and gaining access to these valuable resources, or joining our directory of experts.